All right. It looks like we are live. What is going on, BriHive? It has been a long time since we've been on a live stream. Today we have a couple of cases to cover, or couple of cases to cover and get some updates on. I initially stated that we were going to cover, what is it? Laura Owens and Clayton Eckert's update with the motion for basically a new trial and to vacate the judgment. And then we had Tom Sandoval suing Ariana Madix in the revenge porn lawsuit, basically wanting Tom to hold Ariana liable for anything he might have to pay. And then we have a brand new case, the Black Swan criminal case, where this lady is being accused of unaliving her husband, and she's claiming self-defense. They're calling it the Black Swan case because apparently she's a ballerina, and I believe he was a ballerina too. I don't know if I got that right, but anyways, that case is on its way to trial. So we are going to kind of do a from the beginning on that case to see what's going on there. Now, I said I was originally going to cover all three of those cases. However, I did not have enough time to review the Laura Owens and Clayton Eckert to get all updated in order to go through that document, and it's super long. So we are not going to be covering Laura Owens today or Clayton Eckert, same case, but we're not going to be covering that. We are going to be covering Tom Sandoval, the update in that case, with him suing Ariana, and then we're going to jump into the new criminal case of the Black Swan lawsuit, or not lawsuit, criminal charges, where she is first facing second-degree unaliving of her husband, but maybe splitting up. We'll see. Anyways, we are going to go ahead and set the like goal for today's live stream. I know I am streaming late and I also posted late, so we don't have as many friends joining us initially in the live stream. So let me go ahead and see where we are. We are at 5 likes. 4 people watching live. If you have not hit the like button, make sure you do hit the like button on your way in. We are going to go ahead and set our like goal for 50 likes this live stream. I know I set the live stream up late, so we may not make it there, but that's okay. We're still going to have a good time. Again, like goal for the stream is 50 likes. Let's go ahead and see who is watching live. So we need Bossy B to go ahead and bring us in. Okay, that was a short and rambly intro. Short and rambly, but that's okay. We're going to jump into these documents. This Black Swan case is a long, very long. So I want to make sure that we can get through the motion to dismiss because, self-defense. And let me know if y'all agree with this woman with self-defense. And there's a lot in this document, but we are going to start with the Tom Sandoval because it is shorter and short, sweet, and to the point. So anyways, let's say hello to everyone. We got Zoe B, member of the channel. Welcome in. Nice to see you tonight. We got Kelly Ann saying, yay. We are going live late, but we are live. Chelsea B saying, hey, hello. Welcome back into the live stream. Nice to have you in tonight. And then we have Kimmy Locker saying, hi, everyone. Kimmy is our member, our moderator, our consultant, and our paralegal that pulled all of these documents for me. And if we did not have Kimmy, we would not be here streaming today. So make sure you thank Kimmy on your way in. And thank you again, Kimmy, for grabbing the docs. I had a very rough day at work. Stargazer Kawaii says, hi, hello, and welcome back. Nice to have you in tonight. And then we got Chelsea B saying Sandoval is awful. OMG. Like, how do you start this drama? And then I'm like, I don't want to have to pay for it. I probably shouldn't have been sexting this lady, but ex-girlfriend of 10 years, how about you pay for the fact that I ruined your life, okay? And I'm getting you sued right now. So no, I definitely understand. I definitely agree with you there. So as I was saying, I don't know why I yelled that. That was kind of loud. That was really loud. I did not need to do that. Anyways, we are going to jump right into the Tom Sandoval versus Ariana Madix now. It was originally Rachel Leviss suing both Tom Sandoval and Ariana, and now Tom is now suing Ariana too. So let's jump right into that. We got... Okay, do I even have the document open? I do have the document open, so let's go ahead and share the screen on that. How about I add it to the stream, Bri? Let's add that to the stream. Okay. But anyways, for those of you who do not remember this case, this is the case where Rachel Leviss, also known as Raquel Leviss, sued Tom Sandoval and Ariana Madix of Vanderpump Rules, basically saying that they committed revenge porn of her when Ariana found a video of Raquel playing with her lady bits on Tom Sandoval's phone and sent it back to, so Ariana from Tom's phone sent it back to Rachel saying, you dirty slut, basically. She didn't say that, or maybe she didn't say that, but she said something along those lines. And the reason why this is an issue is because Tom Sandoval had been dating Ariana Madix for about 10 years, and Ariana Madix and Rachel Leviss they're friends, right? And so Tom Sandoval is also friends with Raquel, I guess, Rachel, whatever. Anyways, he was hooking up with this girl that was both of their friends behind Ariana's back. So as a reasonable girlfriend of 10 years, Ariana got mad and sent the video right back to Rachel, saying, you dirty slut. And Rachel said, you know what? You messed up my mental health, because then everyone found out about it. Somebody slapped me or punched me, whatever it was that Sheena did to her. And sorry, I lost my train of thought. So she went ahead and slapped her, and Rachel just went through a lot in that moment, okay? So she sued Tom Sandoval and Ariana Madix, basically saying that you guys revenge porned me, and by sending it back to me. I don't know. It's not very clear if it was sent to other people. Rachel believes that it was sent to other people, but they have to go into discovery to figure it out. If you remember the reading of the complaint, Rachel's complaint was really just kind of going in on Bravo, saying like, you made a spectacle of this, which really really hurt my self-esteem and my emotional well-being, and it caused me to kind of go into like an emotional was it a rehab or something that she went into? But she went and got treated in a facility where she had to stay in the facility to get this treatment for her depression and her other mental issues that came from Bravo essentially profiting off of the sharing of this video. Now, like I said, I don't know if it was sent to anyone other than Rachel back from Ariana, but Rachel is alleging that it was sent to other people and that it was shown to other people. That was a very long summary about what we're about to cover. Anyway, so Rachel sues Tom and Ariana for doing revenge porn on him, invading her privacy, all of the things. And then Tom cross sues Ariana, basically saying, you're the one that got me in this mess. You invaded my privacy. You spread it, Rachel's lady bits when this was my private property on my phone. So you should be pretty much fully responsible in this case. So let's go ahead and jump into the documents. I know I was talking a lot, y'all. That was a lot. Okay, let's see here. We got Rachel Leviss and then Tom Sandoval, an individual with Ariana Madix as the defendant. This is Tom Sandoval's cross complaint for comparative indemnity, pay on behalf of us woman, invasion of privacy, violation of Penal Code 502, and declaratory relief. We want the court to decide something right now. Declaratory relief. And let's just get a summary of what Tom says is going on. He's basically going over the parties, which we already talked about them. It's Rachel, Tom, and Ariana. Rachel is suing Tom and Ariana. Tom is also cross-suing Ariana. That's where we are right now. And the summary is on, oh no, I thought there was a summary in this case. Am I true? Oh no, here it is. On or about March 1st, 2023, cross-defendant Madix obtained access to cross-complainant Sandoval's cell phone and reviewed images, information, data, videos, and or communication, including but not limited to FaceTime videos between Leviss and Sandoval without Sandoval's authorization or permission. Sandoval is informed and believes and thereon alleges that Madix made copies of the data and distributed the data to Leviss and third parties without Sandoval's authorization or permission. And I misspoke earlier when I said that Ariana sent it from Tom Sandoval's phone back to Rachel. I believe she sent it to herself and then sent it over to Rachel from her own phone, calling her a dirty slut. Okay, so let's get into it. Comparative indemnity. They go ahead and restate that on June 13th, 2024, plaintiff Leviss filed the first amended complaint herein against cross-complainant Sandoval and cross-defendant Madix seeking damages for personal injuries, legal fees, therapy expenses, medical and related expenses, civil penalties, and punitive damages that Leviss allegedly sustained as a result of Madix's unauthorized and unpermitted access to, use of, and copying of the data on Sandoval's cell phone and distributed the same to Leviss and third parties as set forth in paragraph 4 herein. So essentially, let's see, they say if plaintiff Leviss sustains damages as alleged in her first amended complaint, these damages were caused entirely or in part by cross defendants as set forth herein. Now, where I do not agree with Sandoval on this is because Rachel also said you recorded this video without her permission. They were on FaceTime. It's not automatically recorded. And Tom Sandoval decided to record this video. Had it not been for Tom Sandoval recording the video, there would not have been a video, or maybe there would have been a different video if Rachel, voluntarily sent it to him. But at this time, there would not have been a video for Ariana to discover had Tom not recorded the FaceTime call between him and Rachel. Let me know what y'all think about that. Am I tripping on that, or do we think it's actually Tom Sandoval's fault? And one, he shouldn't have been cheating. That's his first issue. That is the first issue, sir. You were the one cheating. And then you have the nerve to record a FaceTime call that you were not permitted to record, allegedly, according to Rachel's complaint. She did not give permission to record it. They also go into invasion of privacy. Sandoval goes on to say, okay, without cross-complaint in Sandoval's consent or authorization, Madix invaded Sandoval's right to privacy. The intrusion was offensive and objectionable to Sandoval and to a reasonable person of ordinary sensibilities. I don't know. Let me know if y'all agree. This woman that has been with this man for 10 years looked in his phone and found naked videos of her friend. Is that reasonable? Like, is that offensive to a reasonable person? No, you just got caught. I'm sorry. I know some people don't believe in going through phones, but if you got that kind of stuff on your phone, you cannot then blame the person that you're with for looking at your phone and discovering the nastiness that you have there. So I don't agree that this was offensive and objectionable to a reasonable person of ordinary sensibilities, but let me know if y'all agree to that. He goes on to say the intrusion was into a place or thing that was private and entitled to be private, that it involved an unconsented and unauthorized invasion into Sandoval's cell phone and private data. Again, these people were together for 10 years. Ariana said the phone happened to be open, but at the same time, she was also able to reopen it. So the question is, was this privacy in their relationship? Did they have authority to go through each other's phone? That's what I would like to know. I don't know how strong this argument is, Tom. In performing the acts alleged, cross-defendant was guilty of oppression, fraud, or malice, and the cross-defendants acted with intent to vex, injure, or annoy cross-complainant, and or with a willful and conscious disregard of cross-complainant's rights. Cross-complainant therefore seeks an award for punitive damages. So he is asking that Ariana pay him a little bit extra for causing this mess by sending these videos. They go on to say, cross-defendant Madix, unauthorized and unpermitted access to, use of, and copying of the data on Sandoval's cell phone and her distribution of the same to Leviss and known or unknown third parties constitute a violation of Penal Code 502C. In performing the acts herein alleged, cross-defendants was guilty of oppression, fraud, or malice, and that cross-defendants acted with the intent to vex, injure, or annoy cross-complainant and or with willful or conscious disregard of cross-complainant's rights. Cross-complainant, therefore, again, asked for punitive damages because she went in the phone and she sent this information to people, okay? And then he's asking for declaratory relief. He's asking for the court to make a decision on Ariana's behavior in this case. So An actual controversy has arisen and now exists between cross-complainant and cross-defendant, in that cross-complainant contends and cross-defendant denies the following: that as between cross-complainant and cross-defendant, responsibility, if any, for the damages claimed by plaintiff herein rests entirely or partially on cross-defendant. So Tom is trying to say that Ariana should pay for it all, and Ariana does not agree that she should pay for it all if Rachel is able to prove her case. Then the other issue is that as a result, cross-defendant is obligated to partially or fully indemnify cross-complainant for any sums that cross-complainant may be compelled to pay as the result of any damages, judgment, or other award recovered by plaintiff against cross-complainant. So if it is found that Ariana is responsible for the payment, she should have to make the full payment. Those are the two issues: whether she's responsible and whether she should make the full payment. Cross-complainant desires a judicial determination of the respective rights and duties of cross-complainant and cross-defendant with respect to the damages claimed in the complaint of plaintiff herein. I think that is equal. Tom, you recorded the video. Ariana, you sent the video. Do I think it's offensive to a reasonable person? No. What I do think is offensive to a reasonable person is playing with your lady bits to your friends, when I think they were like best friends at the times, to her boyfriend, to her man. Okay, that's offensive. But her discovering the video and sending it back to you, that's not offensive. Her telling people that she discovered the video, that's not offensive. If she sent it to other people, that is when it will be offensive. Okay. In particular, cross-complainant desires a declaration of the comparative liability of cross-complainants and cross-defendant for these damages, and a declaration of cross-defendant's responsibility for comparative indemnity to cross-complainant for any sums that cross-complainant may be compelled to pay, and for which cross-defendant is determined responsible entirely or in part. That's a lot. That's a lot. It's just that he wants Ariana to pay the damages if they are found to be liable. Such a declaration is necessary and appropriate at this time in order that cross-complainant may ascertain rights and duties with respect to plaintiff's claims for damages. Furthermore, the claims of a plaintiff and the claims of cross-complainant arise out of the same transaction, and determination of both in one proceeding is necessary and appropriate in order to avoid the multiplicity of actions that would result if cross-complainant is required now to defend against the claims of plaintiff and then bring a separate action against cross-defendant for indemnification of sums that cross-complainant may be compelled to pay as a result of any damages, judgment, or other awards recovered by plaintiff against cross-complainant. So he doesn't want to have to pay up. He wants a determination if Ariana is responsible now, so that he doesn't have to pay if the case is proven against him. However, I don't think that they can make that determination at this point in the case. Maybe later on down the line, sure. But at this point, I don't think they can make that determination. So prayer for relief, the determination of comparative fault of cross-complainant and cross-defendant for the damages claimed by plaintiff, if any are found to exist. And then we have for a declaration of the amount cross-defendant is obligated to indemnify cross-complainant if cross-complainant is compelled to pay any sum as the result of any damages, judgment, or other awards recovered by plaintiff against cross-complainant. For a preliminary injunction and permanent injunction enjoining cross-defendant and her agents, servants, employees, and all such persons acting under, in concert with, or for her from continuing to publish the above described data. If she's still sending this video, that's insane. For general, or I don't think they have shown any evidence that she sent it to anyone else other than Rachel. So we'll see how that goes. For general damages, according to Brew, for compensatory damages pursuant to the Penal Code, Section 502, and for exemplary or punitive damages under Civil Code 3294 and Penal Code 502E. For pre- and post-judgment interest at a rate maximally allowed by law. For reasonable attorney's fees pursuant to statute, including Penal Code 502E2, for costs for suit herein occurred, and for such other and further relief the court may deem necessary and proper. So essentially all he is asking for is for Ariana to pay his part of any damages that Rachel recovers in the lawsuit. And he wants the court to find that Ariana is partially or fully responsible for this lawsuit even arising. So she should have to be the one that pays and not Tom Sandoval. Again, like I said it earlier, I don't think that he's going to be able to show that he is not at least partially responsible. But as far as the dissemination and Ariana sending those videos out to Rachel, I think he possibly can win on an indemnity. You pay my part, or if I pay, you have to pay me back for whatever I pay to her. It's a messed up thing. They were dating for a very long time, and to turn around and do this to your ex-partner, you cheated on her, y'all two get sued, and you decide to file something asking for her to indemnify you. Bro, just take your L. Don't be, but that's just his personality. I don't know what this girl was thinking. He is an a-hole from start to finish. So I honestly don't put this back past him. He's suing her for more of the house that they own together, claiming that he paid more into the house. So it definitely does not surprise me that he's trying to get money out of her in this lawsuit and in the house lawsuit. And if anything else comes up where he can get money out of her, I will not be surprised if he is on that side of trying to get money out of this girl. His ex-girlfriend, 10 years this guy did this to this girl. So let's go ahead and see what the chat has to say. And for those of you who do not know what the like goal is, our like goal is 50 likes for the live stream. We are currently at 14 likes, so shout out to the BriHive for hitting that like button. Again, I posted the stream late, so we don't really have a lot of friends in the live stream, but that is okay. That is okay. We're still having a great time. We got Kimmy Locker saying, it's cliche but true, with friends like that, who needs enemy? Yeah, exactly. Y'all are all messing around and then have the nerve to sue people. Like, if you thought that the story brought too much attention to you initially, maybe, just maybe, you shouldn't sue. Like, you should just cut your losses and move on. But now you're bringing more attention to this, more attention to it. Okay, we got Stargazer Kawaii says, I don't have much sympathy for the cheaters. Exactly, don't. But she does have a right to sue, sadly, right? Kimmy Locker says, Stargazer Kawaii, yeah, they unmade the bed, so now they can lie in it. And the other thing about it is, I think that will also have an effect on how much damages she can recover, because if the jury does not find sympathy for her, they may say, oh yeah, they did you wrong, here's $1, you won your case, versus like actual damages, which, I mean, they can't really overcome the actual damages, or they could say she didn't prove her actual damages, which would be kind of messed up, but they can give her like nominal damages and $1, yeah, they violated your rights, but also you was violating by sleeping with that lady's man, okay? Stargazer Kwai says, as far as I know, the video didn't make the public, so all the public attention she gets is for her own actions, cheating, not the result of the video. Exactly. And her position is that Ariana must have showed other people because Ariana had it in her possession. I don't think there has been any evidence presented to show that Ariana showed anyone else the video. She told other people about it, but there's nothing against her telling other people about her finding an exposed video of this girl on her man's phone. There's no law against that. Cheryl Reed says, Tom is ick personified. Yeah, he's horrible. Stargazer Kawaii says, it's not offensive for a partner to use your phones. Couples do it all the time. I agree with that. I don't think it's offensive to use the phone. And what's maybe offensive is having a naked video of your girlfriend's friend on your phone. That is offensive, okay? Kimmy Locker says, I could almost understand Sandoval making a play for indemnity, but asking for punitive damages is foul. Yeah, he needs to be the only one getting punitive damages. He was the one that was the wrong in the whole thing. Like, he's the one cheating. He's the one recording the video without permission. He's the one leaving the video on his phone for his girl to find. If anybody should be getting punitive damages, it should be him, not Ariana. Like I said, I do think that he has a partial claim for indemnity regarding the dissemination of the video, but I think he's responsible for recording the video. Okay. Stargazer Kawaii says, the idea that they have the courage to take the women they harm to court with this is shameful. Yeah. And that's what he's doing. He's like, yeah, I effed up, but you're going to suffer more than me. Like, I've already made you suffer emotionally. I'm going to make you suffer even more. Kimmy Lockett says to Stargazer, Stargazer Kawaii, it's the strangest combination of shameful and shameless. Like, what are you guys doing? And that's what he's doing. He's trying to get, justice for himself, I guess. Cheryl Reed says, I agree, Kimmy, the audacity. Stargazer Kawaii says, I hope she didn't send the video to anyone and these losers have to pay her court costs. I hope so too. And the thing is, they're going to say, oh, well, she showed it to people directly off of her phone. It's like, how do you prove that? How do you prove that? Destined to be moderator and member of the channel, welcome in, saying, hey, BriHive, I'm here. And I hit the like button on the way in, dropping the queen bee. Thank you very much. We definitely appreciate it. And happy to have you here live. We got Stargazer Kawaii saying, if he took the video without permission, he should be held responsible. Do you think he should indemnify Ariana? Because like I said, had he not recorded the video, there would be no video to disseminate or find. Maybe there would be, but at least it wouldn't be the video he recorded, right? Chelsea B says he files this lawsuit and then deletes all his socials. Clearly, he knows he's a dirtbag. Did he delete all of his socials? I did not know about that. That is strange. Cheryl Reed says they should just sit down and be quiet. They should just be quiet. Like, everyone forgot about this until she sued them. Like, literally, everyone forgot about this. Everyone. Stargazer Kawaii says, I don't know why she would share the video with anyone else. Who would want to see that? What she's probably thinking it is, it's like revenge. She's so mad. And this is like a reality TV show. These people are all on a reality TV show. They have pretty close friendships within the friend group. And what's her name? Rachel is alleging is that Ariana sent it to other friends in the friend group and also sent it to the production company Bravo. There's no evidence of that, and they would have to do some forensic evaluation of Ariana's phone, which I think Ariana has already presented some forensic evaluation of her phone, and that she just texted her friend and that it was only sent to Rachel. But they would probably do more research on the phone to see whether it was sent to anyone else in any other manner. So I hope she didn't send it, but basically Rachel's position is that she was so mad she sent it to our other friends or even our production company. I don't know if she'll be able to prove it. I really hope she can't prove it, and then the lawsuit just like goes away. Tanya D says, or it's destined to be says, Stargazer, I'd be too mad if someone sent me the video. Right? Like, I did not want to see that. Why would you send that to me? Kimmy Lockett says, yep, so people directed their thoughts and opinions to the bar's social media accounts. Oh yeah, I did see that. Did he delete his social medias recently or right when the lawsuit came out? But I did see people kind of tarnishing the bar, but there's also people that still go to the bar. I don't know. I used to want to try the bar, but now I'm not. Well, I never wanted to try Swartz and Sandy's, but I didn't want to try Tom Tom. So, but also they sell like bar food, so maybe not. Especially after all this nonsense. Let me know what y'all think if you're watching on the replay in the comments. And like I said earlier in the stream, if you missed it, we are not going to be covering Laura Owens and Clayton Echard because I did not have enough time to familiarize myself with what those Looney Tunes are claiming. And it's a lot of pages, and we have a lot of pages to get through for the new lawsuit that we're covering, or not the new lawsuit, the new, trial, criminal prosecution that we're going to be covering. So let's go ahead and jump into the introduction of this new case that we're going to take a look at. And let me know in the comments if y'all have heard about it, if y'all are interested in it. The trial is starting probably sometime next week or the week thereafter. And we are pretty interested in covering the case. So let's go ahead and jump into that. All righty. So new case. Let me know if y'all have heard about it. They're calling it the Black Swan case. This lady, what is her name? I forgot her name that fast. I think Ashley. Ashley Christina Benefield is being prosecuted for the unaliving of her ex-husband, or her husband. I guess he was still her husband at the time. And she is claiming self-defense. From my knowledge, she is a ballerina, so they are calling it Black Swan, like the ballet. I can't remember. I believe he is also a ballerina, or dance, some type of dancer. Can y'all correct me if I'm wrong? But anyways, she is being accused of shooting this guy dead. And honestly, she's not objecting to the fact that she did this. She is saying she did it. but it was self-defense. But let's get into the facts of how this ended up happening. We're going to start off with the complaint. Again, in the chat, on the replay, in the comment section, let me know if you have heard about this case before. And y'all, don't forget, we have a like goal of 50 likes and we are at 16 likes. So make sure you hit the like button if you have not already. So let's jump into it. This is the complaint for the arrest. On September 27, 2020, John Sant contacted 911 and reported that his neighbor, Ashley Benefield, had just run over to his residence and told him that she had been attacked by her husband, Douglas Benefield, and that she had shot him. So she admitted to it immediately. She never denied it, right? John Sant confirmed that the shooting took place at Ashley's residence, which was located at this address. John Sant also told the dispatchers that the weapon used was currently in his residence. John Sant remained on the phone and in the presence of Ashley until she was directed to go out and meet with deputies. John then directed deputies to the firearm, which was still inside his residence. And I just like, if she came in there with a gun, talk about, I just shot my husband, did he take it from her? Because you would have had to take that from her. Like, yeah, you're not about to just be sitting there waving that around, telling me to call the police, and you might get trigger happy and then shoot me. So, yeah, I wouldn't trust that too much. But anyways, responding deputies entered the location of Ashley's house and began to render aid to Douglas Benefield, who was found on the floor of Ashley's bedroom. Douglas was moved to the living room where the deputies continued to render aid. Douglas had 2 gunshot wounds visible on his person. The wounds were located on his right leg, right arm, and right chest. Douglas was eventually transported by EMS to the nearest hospital. Douglas succumbed to his injuries and was pronounced deceased at 8:09 p.m. A search warrant was obtained for the residence, and during the execution, it was discovered that a total of 4 shots were fired. 4 .45 caliber casings were located on the floor in Ashley's bedroom. A loose projectile was also found on the floor, and 2 more were found embedded in the walls of the residence. Ashley was transported to CID by patrol for an interview. Prior to her arrival, Ashley's legal counsel had already arrived. Ashley and counsel advised she did not wish to make a statement at the time. Ashley did, however, make a spontaneous statement to me advising that her ears were still ringing, basically insinuating that she probably shot a gun or was at least around somewhere where a gun was shot. Ashley was shown to the interview room so that she could confer with her counsel. As we walked to the interview room, I did not observe Ashley to have any injuries, nor did I observe any ripped, torn, or stretched out clothing. And the reason why that is important is because she is claiming self-defense. So she's claiming self-defense. She shot this guy, and she has no injuries, no torn clothing, nothing to demonstrate that she was in a struggle before she fired this gun. They go on to say, in the narrative, a search warrant was obtained for photographs as well as DNA from Ashley's person. I reviewed the photos. I reviewed the photographs and spoke with the crime scene technician. No injuries aside from a minor scratch on her right side was visible. The scratch appeared to be old and very minor. Upon further investigation, a witness explained that Ashley had obtained the scratch on her right side the day before the shooting when she was inadvertently scratched when someone walked by her carrying a box. This part kind of shocked me because who is this witness and how would they just happen to know where she got that scratch? Because the only time I really know why someone has a scratch, like the person would have had to scratch her with a box and then show, oh, look, oh my gosh, it broke skin or whatever it may be. But the only person I know that about is like my husband, like not just a random person. So it had to be like at work or something. And she said something about it, but I thought that was strange that they were like, oh yeah, that came from yesterday and someone walked by her with a box. Half the time when I have scratches on my own body, I don't know where they come from. So I thought that was an interesting point that the witness happened to know that. Douglas was found to have been shot twice. One of the rounds entered the outside of his right leg and exited the inside of his right leg. The other round appeared to have skipped across his right bicep and entered his chest cavity from his right side. No signs of stippling were observed on Douglas or his clothing. or his clothing, indicating that the firearm was several feet away when it was fired. So again, self-defense, maybe you're in a struggle, maybe you're in a struggle for a gun, but the police are indicating that there was no stipulant, so no signs that the firearm was very close to him, which insinuates that she fired it from far away, and it reduces the likelihood of this being self-defense, okay? Douglas was, already got that one. Based on the entry wounds of Douglas, or based on the entry rooms on Douglas, it does not appear that he was facing Ashley when she began shooting. It also does not appear that Douglas had taken any kind of defensive or combative stance. After being shot, Douglas fell to the ground, and it appears that he may have struck his head on the wall on the way down. Douglas did have an abrasion on his back of his head, which was about the same size as a small patch of disturbed drywall on the eastern wall of the bedroom. So there's basically like a hole in the wall that he probably hit his head on. Douglas was not found to have any weapons on his person or near him. On October 1st, 2020, a second search warrant for photographs was executed on Ashley for any delayed injuries that may have not been visible on the night of the shooting. No injuries were observed. Numerous requests have been made through Ashley's legal counsel to set up an interview to discuss what occurred in the room that night. As of this writing, Ashley has not provided a statement or interview, which is smart on her end. A lot of people, they were like, you don't speak to the police. And then as soon as something happens, they speak to a police without their lawyer present. In this instance, she didn't speak to the police without her lawyer present, but they still arrested her because it seems like they had just enough evidence against her. During the investigation, it was found that since the time Ashley found out she was pregnant with the child that she and Douglas share, she has made several allegations against Douglas. While looking into the outcomes of the numerous cases, it was found that they had never resulted in criminal charges and were furthermore closed as unfounded. None of the cases involved the allegations of physical domestic violence. Based on these cases and Ashley's actions leading up to the unaliving of Douglas Benefield, it appears that the main focus of these complaints was to keep the child away from Douglas. In one of the most recent cases, Ashley and Douglas went before the Honorable Judge Moreland for an injunction hearing. During the hearing, Judge Moreland openly advised that she did not find Ashley's story to possess a scintilla of truth. So she's a liar, pants on fire. Judge Moreland further ordered Douglas to have access to the child for visitation. At this point, it appears that Ashley had exhausted all legal means to keep the child away from Douglas before the shooting. So, main reason why they probably found that this was not self-defense was because she had so much documentation already pending, trying to get restraining orders against this guy, trying to prevent him from seeing his kid, all of these things in order to keep him away from his kid. When the judge was like, no, he can still see his kid, this shooting followed shortly after. So to me, that's very interesting. Let me know what y'all think about that. Do you think that she still could have done self-defense in this scenario? Or does this sound like something she kind of planned or at least was ready to do if any indication that he was being mean to her, she was willing to shoot this man dead? And to me, it sounds like if it was any indication that he was being mean to her, she was going to shoot that man. And she's in the house, okay? She's in the house. Her lawyer has talked about this was not a normal battered wife's defense. This is like an unusual one because the battered wife is no longer living in the house. So it sounds like she was kind of visiting him or he was visiting her. I don't know the exact order of it, but they were not living together at the time that he was shot, which makes it even harder for a battered wife syndrome. You're there by yourself. It's seemingly the daughter is not there during this time. So what are you doing over there but to unalive him, right? So the charge that she is being charged with is murder in the second degree with a firearm. And it happened on September 27 of 2020. She did a dangerous act, which resulted in Douglas being unalived by the gun. So let me go ahead and jump over right to the motion to dismiss because this is a self-defense claim. So she is saying that this case should not go to trial because she was doing self-defense. She was a battered wife. who basically went through a lot of abuse or a lot of, manipulation during the marriage. And this resulted based on kind of escalating circumstances, right? He's fighting her for the daughter. They're breaking up. She's been abused throughout the relationship. And she just happened to go over to talk to him and ended up unaliving him by shooting him twice, once in the leg and once in the chest, kind of from the side. It's an interesting position. So I do want to go over the motion to dismiss the claim based on self-defense. I have not reviewed this entire document, but I do want to review it on the live stream. So that is what we're about to do right now. So I'll probably go like halfway through it. And then and Kimmy did tell me about the highlighting, but I was unable to see the highlighting on my iPad. So let me go back and check what the highlighting stands for. I was just reading the whole thing on the iPad. So you said that the blue is informational. Well, this one is pink, and you don't have anything for pink. Okay. I don't have anything green. Why is it showing pink? Oh, dang. Never mind. I completely misunderstood. Anyways, here we are with the request to dismiss by the defendant. This matter came before the court for a hearing on July 6th and 7th of 2023. So they've already had this hearing last year, about a year ago, on the defendant's motion to dismiss request for a declaration of immunity and incorporated memorandum of law filed on February 1st, 2023. Motion or defendant's motion, State Assistant Attorney Suzanne O'Donnell and Rebecca Field represented the state of Florida. Neil Taylor represented the defendant. All attorneys, parties, and witnesses appeared in person before the court. Let's see here. Having reviewed the defendant's motion, received evidence, heard argument of counsel, and considered the applicable Florida statutes and relevant case law, and otherwise been duly advised of the premise of the court finds that the state has proven by clear and convincing evidence that the defendant is not entitled to court-ordered immunity from prosecution, and denies defendant's motion to dismiss the request for a declaration of immunity. So she asked for the court to find that she's not liable for this unaliving because she was defending herself. The court said, no, there is enough evidence to show that this was not self-defense. So what is the stand your ground law in Florida? In general, you are able to defend yourself in your house, right? Even if it's by deadly force, which is a gun. Most of the time it's a gun. And let's see what Florida says. Laws of Florida became effective in October 2005 and made substantive and procedural changes in the statute. In response to the initial conflicts among the court regarding certain aspects of the new provision in Chapter 776, the Florida's legislature enacted several statutory clarifications in recent years between... I don't think I want to go through the procedural changes. I just want to know what it is. Sorry, y'all, I didn't review this part earlier, so let's go through it. Okay, I guess I do have to read this part. Okay, here we go. Sorry, I skipped right over it. To seek court order immunity from criminal prosecution for the use of threat and To seek court order immunity from criminal prosecution for the use or threatened use of deadly force, a criminal defendant must raise a prima facie claim of self-defense immunity at a pretrial immunity hearing. Once the defendant makes the prima facie showing, that burden shifts to the state to prove by clear and convincing evidence that the defendant is not entitled to immunity. There is no requirement that a SYG motion, a self-defense or stand your ground motion, be sworn to be verified. Let's see. And the person claiming immunity has no burden to prove a prima facie case. Let's see. Thus, instead of calling witnesses or presenting evidence to prove her prima facie claim, the defendant must simply allege a facially sufficient prima facie claim of justifiable use of force under Chapter 776 in a motion to dismiss filed under Rule whatever, and present argument in support of the motion at a pretrial immunity hearing. A trial judge must then determine at first glance if all elements required to demonstrate the particular self-defense statute are present. Prima facie is defined as which the sufficient to establish a fact or raise a presumption unless disproved or rebutted based on what seems to be true on first examination, even though it may be later proved to be untrue. As noted above, once the defendant raises the prima facie claim of self-defense immunity from prosecution, the burden shifts to the state. Thus, while the defendant need only plead prima facie claim of self-defense in her motion, the state is required to present evidence at the stand your ground hearing, and that evidence must prove clearly and convincingly that the defendant is not entitled to immunity. So all Ashley has to do is say, I have a self-defense claim because he was attacking me, and I defended myself by shooting him. My force was necessary because he's bigger than me, blah, blah, blah. I don't know exactly what was said because I only skimmed this document. But she just has to say that, right? I'm claiming self-defense, essentially. I'm claiming self-defense. Then it shifts over to the state to say, no, sweetie, this is not self-defense. So after the state has presented its case, the defendant has the opportunity to present evidence and rebuttal. At that point, however, the defendant may not just rely on factual averments in her unsworn, unverified motion. Rather, the defendant would need to introduce evidence into the record. The defendant can testify, but unlike a motion to suppress, a stand your ground motion for immunity is a creature of statutory construction and does not implicate constitutional rights. Thus, the defendant is not faced with the choice of testifying or foregoing important constitutional claims, and her testimony at the stand your ground hearing can be used as substantive evidence in future proceedings. So you have to testify in the stand your ground hearing, and they get to use it against you. So it's nice to try to prove that you're not guilty early, but you could potentially incriminate yourself if you do that. So immunity from criminal prosecution for justifiable use of force. If Ashley Benefield used force as permitted under the statute, she is justified in such conduct and is immune from criminal prosecution for the use of such force. Ashley Benefield would be justified in using deadly force against Doug Benefield if she reasonably believed that using such force was necessary to prevent imminent death or great bodily harm to herself or to prevent the imminent commission of forcible felony. If Ashley Benefield used deadly force in accordance with the subsection, she did not have a duty to retreat or had the right to stand her ground if she was not engaged in criminal activity and was in a place where she had a right to be. So was she the one living in the home, or was Doug the one living in the home? If Ashley Benefield was in a dwelling or residence in which she had the right to be, she had no duty to retreat and the right to stand her ground and use deadly force if she reasonably believed that using such force was necessary to prevent imminent death or great bodily harm to herself or to prevent the imminent commission of forcible felony. Ashley Benefield would be justified in using deadly force in the defense of property only if she reasonably believed that such conduct was necessary to prevent imminent commission of a forcible felony. If Ashley Benefield used force in accordance with the subsection, she did not have a duty to retreat and had the right to stand her ground if she was not engaged in criminal activity and was in a place where she had the right to be. So did she have the right to be in the house at that time? Was she living there? What was going on here? Was she still the owner? Those questions come into place. Forcible felony means murder, manslaughter, sexual battery, burglary, kidnapping, aggravated assault, aggravated battery, aggravated stalking, and any other felony which involves the use of or threat of physical force or violence against an individual. Now, she's going to have to say she thought he was going to beat her or unalive her in this instance. Okay, use or threatened use of force by the aggressor. The justification described in the preceding sections of this chapter is not available to Ashley Benefield if she was attempting to committing, or escaping after the commission of a forcible felony. The justification described in the preceding section of this chapter is not available to Ashley if she initially provoked the use or threatened use by force by Doug Benefield against herself, unless the force or threat of force by Doug was so great that Ashley Benefield reasonably believed that she was in imminent danger or death or great bodily harm, that she had exhausted every reasonable means to escape such danger. Other than the use of force, which is likely to cause death or great bodily harm to Doug. In good faith, Ashley withdrew from physical contact with Doug and indicated clearly to Doug that that she desired to withdraw and terminate the use or threatened use of force, but Doug continued to or resumed his use of threatening use of force. In addition to the statutory establishment of the elements above, Second DCA explained that when a court considers the evidence, an objective standard applies, and the trial court must determine, based on the circumstances, that they appear to the defendant a reasonable and prudent person situated in the same circumstances and knowing what the defendant knew would have used the same force and did as did the defendant. The appearance of danger must have been so real that a reasonable, cautious, and prudent person under the same circumstances would have believed that the danger could have been avoided only through the use of the force. So, did she have a right to be there? Was there a threat of force? Did she try retreating if she started the force? And would a reasonable person do the same thing she did in that moment? We're going to get into the facts. I don't know the facts, y'all. This is my first time going through this. I only skimmed it very briefly before this live stream. So we're going to jump into what the defense said happened in their motion. And then we're going to jump into the evidence that was presented during the trial. And I believe the trial is available online, but I'm not quite sure. So let's check it out. What happened in the defense motions? In an effort to use the available hearing time efficiently, the court directed the parties to meet and confer on legal sufficiency of the defendant's motion and whether it raised a prima facie claim of immunity so as to shift the burden of proof to the state. The parties entered into a written stipulation that defendant's motion raised a prima facie claim for self-defense, and the court ratified the parties' agreement via stipulation on June 16, 2023. In the motion and throughout the hearing, the defendant, through her attorney, set forth the reason why she believed it was reasonable and necessary for her to use deadly force against the victim. These reasons generally fell into three categories, including events that occurred prior to September 27, 2020, general temperaments, habits, and physical shape and training of Mr. Benefield, and events on September 27, 2020. So we are talking about a battered wife's defense. He had been like this previously, so I knew I needed to defend myself. Okay. At the hearing, the state rested. The defendant did not testify and called no witnesses. Instead, the defendant relied on the allegations in her motions and the attachment thereto as evidence to support her claim of immunity. She argued that her unverified and unsworn motion to dismiss was substantive evidence that the court can and should consider in the making the decision whether to grant or deny the immunity. Okay. So I was just trying to make sure we're going to go over to the facts because they kind of gave us a little summary of the facts, but not necessarily what she's claiming. But this footnote does describe what happened on September 27th or on all of those days that led her to believe that she needed to use physical force in this situation. So let's get into it. Events that occurred prior to September 27, 2020, she claimed, and the court found that they didn't determine whether it was fact or not fact. They just are taking it on its face, okay? So events that happened prior to the date of the unaliving, Doug intentionally fired a handgun into the ceiling of their kitchen in South Carolina to intimidate her. He threw a loaded gun at her. He punched their dog in the face hard enough to render the canine unconscious. He unlawfully placed a tracker on her car. Ashley frequently observed Doug telling her car he punched numerous holes in the walls of their home. His previous marriage had a history of domestic violence. Ashley suspected that Doug poisoned his first wife and poisoned or attempted to poison Ashley and their child while in utero. And he was caught by the neighbor at night standing in Ashley's backyard and peering into her window. Those are some serious allegations. General temperament, habits, and physical shape and training of Mr. Benefield. Doug regularly carried a loaded concealed firearm. He was in substantially better physical shape and physically stronger than she was. He had training in martial arts, hand-to-hand combat, and judo, which she did not have. He was moody, unpredictable, and vacillated between calm and rage. And he was controlling, verbally threatening, intimidating, and psychologically abusive. So again, we don't have any physical abuse. She has filed restraining orders in the past, but they did not include claims of physical abuse. She's just basically saying he's intimidating to her. The shooting the gun into the ceiling is pretty domestic violence to me, but he has not, from what it sounds like, physically touched her. And of course, she's going to say he's bigger than him. He's a man. Generally, men, generally men are bigger. And even if they're not bigger, they're generally stronger than women just by genetics. So events on September 27, 2020. So what happened that led to her pulling the trigger? Doug deliberately rammed, slammed, or body checked Ashley on 2 occasions while they were moving, and then struck her in the side with a box as they passed each other in the hallway, causing her to lose balance and suffer scratches to her body. So she's claiming that the scratch came from the box in his hand, and a witness is claiming that the box scratch came from the day before. So interesting. The day before she was interviewed. So that's interesting. Okay. He struck her with a box while they were passing in the hallway, causing her to lose balance and suffer scratches to her body. He became a trespasser in her residence when she expressly revoked her consent for him to be there and instructed him to leave. And he subsequently committed a battery upon her by grabbing her wrist. And he committed 1 more forcible felonies in her residence by remaining in the home after she expressly revoked her consent for him to be there, grabbed her by the wrist to stop her from leaving the home, used his body to physically block her egress, ground his knuckle into her temple, and approached her in an aggressive, threatening manner while she was in her bedroom. So it sounds like he was there to move some of his stuff out of the house, and she was the one remaining in the house. That's what I'm picking up on it. Let me know if y'all are picking up the same thing. Okay, the defendant's motion to dismiss and attachments were filed in the court. They were not marked for identification purposes in the evidence. Okay, so that is what he did, in her words, that led to her unaliving him. He grabbed her wrist and got all in her face and potentially yelled at her, and I guess did this to her her temple. After reviewing the cases cited by defendant Casanova and Penavlar, the court finds that they are not instructive on the point being considered, as both involve whether an unsworn and unverified motion to dismiss containing sufficient factual accusations can establish a prima facie case for self-defense immunity. This is not an issue here because the parties entered into a written stipulation that the court signed an order finding that the defendant's motion was sufficiently pled. The question is whether the same unsworn, unverified motion to dismiss can be considered by the court as substantive evidence during a stand your ground hearing. The defendant argues that it can, and the state argues that it cannot. The issue came up briefly on the first day of the hearing and again during the closing argument, and neither party provided the court with the case on this point. The court finds that the answers provided in Edwards versus State. In Edwards, the defendant appealed the denial of his stand your ground motion. The majority opinion suggested that defendant did not present sufficient facts in his motion to raise a prima facie claim, noting that conclusory allegations of self-defense are not enough, but the court did not rule on the sufficiency of his pleading because the state did not challenge whether Edward raised a prima facie case on self-defense immunity at the pre-trial hearing. Important to the issue at hand is Mrs. Benefield's case. The majority in Edwards found that the unsworn allegation in Edwards' motion lacked evidentiary value. In support of this finding, the majority cited this other case. Unsworn representations of counsel about factual matters are not competent evidence absent a stipulation. The opinion in MTSLQ investors in turn cites Schaefer, another case. Documents not authenticated or entered into evidence are not properly before the court and cannot constitute evidence. Unsworn representations of counsel about factual matters do not have any evidentiary weight in the absence of the stipulation. Why is this important in this case? Because she did not put on a defense. So to start the case, she has to do a prima facie claim in a motion, which she did. And then the state has the burden to prove why self-defense doesn't apply. In this case, Ashley decided not to then rebut what the state said by presenting her own evidence, because had she presented her own evidence, she would have had to testify, which could result in her incriminating herself, and any statements that she said during this hearing could be used against her if this were to proceed to trial. Her attorney did not move for this document, the motion to dismiss, to be entered into evidence. And also, since it's unsworn, meaning that she did not sign it saying this is what happened and this is what I'm putting forth as my testimony, it's not satisfactory to hold any evidentiary weight. So it's not evidence. So in essence, she screwed herself by not presenting a rebuttal to what the state presented in their defense of her motion to dismiss. So there's that. Sorry, sis. More recently, in Roberts versus State, Florida newest appellate court answered a similar question in the negative when it found that the state's unsworn motion and its unsigned unsworn attachments were not evidence that could be used to establish the legal basis for the issuance of a subpoena of the defendant's medical records as part of a DUI investigation. The Roberts court found that the trial court departed from the essential requirement of the law when it granted the state's motion to issue the subpoena, because to obtain subpoena of medical records, the state must present argument and evidence. At the hearing on the motion, the state presented no evidence. We reject the state's contention that making an argument at the hearing that referred to the motion and the attachment satisfied the obligation to present evidence. Having considered the issue presented, heard the argument of counsel, and reviewed the case law, the court finds and concludes that the criminal defendant's unsworn and unverified motion to dismiss, filed pursuant the rule that sufficiently sets forth the prima facie claim for immunity pursuant to the applicable statute, and therefore shifts the burden to the state to overcome the immunity claim with clear and convincing evidence, is not substantive evidence that the court can consider when making factual findings or drawing conclusions. So the only thing that the court is going to consider is the evidence that the state put on. Bad move, Ashley. Based on the finding, the court accepts the defendant's motion as sufficiently pled to open the courthouse doors for the stand your ground hearing and shift the burden to the state, but the court does not consider any of the facts alleged in the defendant's motion or attachments unless those facts were admitted into evidence by some other means. And since she didn't put on a rebuttal, the facts did not come in. It's an unsworn statement. They cannot consider that. Had she testified, that would have been a sworn testimony, that would have been sworn, and the court could have considered it. However, it could be used against her as evidence in the trial. So interesting, y'all. I know I'm not a criminal defendant or a criminal attorney, so I'm learning things here on this live stream. That is very interesting to me, but it makes sense too. Going on to the state's case, they called 8 witnesses. They called Tommy Benefield. Before we get into the state's case, I'm going to cover some chats and then we'll jump back into what the state put on for the court to basically decide that they provided enough evidence. But the thing is, what is there to contest it? She didn't rebut anything. So pretty much any evidence that the state put on pretty much shows that, she didn't overcome her burden. So let me go ahead and jump into the chat to see what y'all are saying. Again, let me know if y'all have heard about this case. We are currently at 23 likes. Our like goal for the stream is 50. Don't know if we're going to make it, but if you haven't hit the like button, please do. It does help us out on the algorithm. And, we're having a good time and we want people to check out this video. So let's see what the chat is saying about the case so far. We got Doodle Noise, member of the channel, welcome back, saying, yes, read about it. How do you like the case? Or not like it, but what is your interest in the case? Stargazer Kawaii says, it's interesting how different some of these self-defense cases turns out. Yeah, it is. And really, it sounds like she probably lost on a technicality because technically she didn't present any evidence of how this was self-defense. And the only thing that the court was able to consider was everything that the state put on. Bad move by her attorney. Tanya D says, I heard the name Black Swan case, but no details. Sound interesting. Same. I had heard about the case, but I thought I read about it, but this is completely new to me. So I was on the wrong track coming into this live stream. Stargazer Kawaii says, I've obviously injured myself at work. Potentially is what they're basically claiming with a scratch. Kimmy Locker says Doug Benefield was a businessman and they started a ballet company together, but I don't think he was a dancer. That makes sense. That actually makes more sense than what I said. Stargazer Kawaii says there's usually obvious signs of women being in physical altercations and less so when men are victims. If one of the problems, it's one of the problems men have with being believed. What do you mean that the men are not believed because the women don't usually have the injuries? Or I don't know if I followed that all the way. Cheryl Reed says, sounds a bit suspicious to me. It does sound suspicious. I agree. And then we have Stargazer saying, so it was her house. I thought it was his house. I think it was both of their houses, but they were married. So like he was moving out. That's what it sounded like to me. Y'all can correct me if I'm wrong. Stargazer says, I'm not sure I would fight to stay at the house if I was afraid of the man. Yeah, while he's moving stuff and bumping all into you, like, but it doesn't really sound like the thing is, she shot him in the bedroom. Like, what was going on there? And if he was like all up in your face doing as she said he put a knuckle to her temple like this. So if he was doing all of that and then he walked away, so you telling me you turned around, grabbed a gun and then shot him, or grabbed a gun and then shot him because you thought he had a gun on him because he normally has a gun on him? I don't know. It sounds really sketchy in my opinion. Stargazer Kawaii says, would it be possible to hide your address from your ex if you share the child together through the court? Not always. If it is a domestic violence incident, then yes, they can allow for that. Excuse me. But in this situation, she had filed harassment order request and everything, and the court keeps denying it. And the court actually called her a liar at her most recent case. So, had she been able to get a restraining order for him, it would have been possible to hide her address. But it has to be like pretty extreme abuse for them to allow you to hide your address. In most cases with domestic violence, you would still have to share your address and you would still have to share your child, at least in California. Don't know how it works all the way in Florida, but assuming it's similar to California, you would still have to share your address. That person who has abused you would still know your address. And a lot of times, your home is protected in a restraining order. So you would have to share your address in order for him to make sure that he's staying away from that home. He can't be like next door at the neighbor and not know that you live there. So it has to be a pretty serious offense if the court is going to allow you to hide your address from the other party when you have a kid, especially. So let's see here. Tiny D or Destined to Be says, that is a good question. And then Tiny D said, I keep saying Tiny D because I see your picture, but I'm like looking at the name and I'm like, let me correct it. Destined to Be says, Florida and their stand your ground laws are crazy, right? Kimmy Lockett says, I don't understand why her attorneys bothered to make a motion to dismiss if they weren't going to put on any evidence. It sounds like they thought as long as they put in the document, that was good enough. And that makes me wonder if that has worked for this attorney on a different case before, because he's not a young attorney. He's like an older man. So, or unless he just became an attorney as an older man, I'm going to assume not, especially in a case like this. I wouldn't hire like a brand new attorney with all this media coverage on the case. But yeah, it seems like he thought just filing the motion was good enough. And honestly, when I read the rule that the court put forward, it sounded like that was it. All they have to do is do a prima facie case, and then then the prosecution puts on their defense why it's not stand your ground, and then the defendant has the option to rebut it or not to rebut it. That's what I got from it. I didn't know that they couldn't then use the declaration to argue, well, we made a prima facie case. But I mean, I guess that's the same thing. And then also it makes sense that the motion to dismiss is unverified and unsworn. So it'll be hard for the court to use that as evidence if we don't even know if she's telling the truth in it. And she doesn't have to admit whether she's telling the truth or not in the documentation. It could all be a lie because it's unsworn and unverified. So it makes sense. But I didn't think, well, what makes sense is that she didn't put on the case. And then so the court only relies on what the state had to say. So there's that. Excuse me. And whatever doubt the defendant caused by questioning and cross-examining the witnesses. Okay. So let's go ahead. Oh, wait. I think there was another one. Stargazer says men don't always have visible injuries. Oh, that makes sense. Like when they're being abused, because maybe the woman's not strong enough to leave a mark. That's just kind of mean, but sometimes that's true. Tanya D said, Destiny B says, all good. I don't mind. Like I'm still struggling. I'll get it together. I will get it together. Okay. Give me a second, y'all. That was weird. Sorry about that, y'all. Sound like something was falling through my house. I'm like, what the heck is going on? I was like so confused. Okay, anyway. Let me go ahead and jump back. Where was I? Did I already bossy B? Let's bossy B again, because I'm confused. Okay, let's go ahead and jump into the state's case. What evidence was put on? What did the court consider? Let's see if we think that the court got it right in saying that she did not prove her burden for a motion to dismiss for self sorry. For self-defense. And maybe we should read the actual motion. That might be helpful to know exactly what she said. But based on the summary given by the court, she basically said that he bumped into her, he shoulder checked her, and he put his hand to her temple and yelled at her aggressively. So that's what we got right now, but I have not read the actual motion to know if there was anything additional into like how a gun ended up in her hand. Did she have to turn around? Did she have to go looking for it? How did the gun end up in her hand? I'm going to have to read the motion to really give my opinion on that. Okay. Anyway, so state's first witness is Tommy Benefield. Although first cousins, Tommy Benefield was closer to Doug than he was to his own brother. From their time as naval aviators through their careers in the private sector, they kept in close contact and spoke monthly, if not weekly, depending on what was going on in their lives. Growing up, Doug was an all-star wrestler in high school, but Tommy Benefield did not know Doug to be trained in martial arts or judo. Remember, wife said that he was trained in martial arts and judo. So basically saying he's an assault weapon as himself. In the time leading up to the homicide, Tommy estimated that Doug was 5'9" or 5'10" and weighed approximately 160 to 170. That's pretty small for a man. While Doug suffered injuries in the past, including a significant back injury in the Navy that led to surgery in 2017, he found relief in recent years from a medical device provided by Tommy Benefield. Toward the end of his life, Doug was doing CrossFit, and as Tommy Benefield described it, was in very good shape. Tommy first met Ashley on April 14, 2017, when he had a layover in Charleston, South Carolina. Doug and Ashley, 54 years old and 24 years old at the time, respectively, lived in Charleston with Doug's teenage daughter and from his first marriages. Okay. I thought I read that he was 54 somewhere, and I was like, maybe that's a typo. Maybe that's a typo. But no, we're talking about a 30-year age difference. I don't like that. Don't have nothing to do with the case, but I don't like that age difference. Okay, let's see. They lived in Charleston with Doug's teenage daughter from his first marriage. Tommy spent approximately 4 hours with the couple and learned Ashley's life story and the story of their relationship, including the fact that they had not known each other for 13 days before they were married. God, what? Okay, I missed all of these facts. They got married in 13 days? That's insane. He also heard about Ashley being a former ballet dancer and how the couple founded the American National Ballet in Charleston on February 27, 2017. While Tommy did not know Doug to be interested in ballet, he could see that Doug was proud of his wife, starstruck, as Tommy described it, and supportive of her desire to create a ballet company. He also learned that Doug had personally done a lot of work to get the ballet up and running, from forming the LLC to building the website. According to Tommy, Doug was not just investing his time to get the ballet company up and running, but he was also investing his money and raising money from donors and investors, including his business partners. To help with the fundraising efforts, Tommy agreed to attend an informal launch planned for August 12, 2017, and bring his business partner. Tommy later learned that during this time, Doug had a vasectomy reversal and that Ashley became pregnant 3 months later. Because of her morning sickness and Doug's travel schedule, the couple decided that it would be better for Ashley to live with her mother in Manatee County, Florida, and Doug moved her down on August 27, 2017. Tommy spoke with Doug by telephone on his way to Florida and on his way back home to South Carolina. The A&B officially launched to the public on September 18, 2017, and had its opening performance on December 7, 2017. By the end of December 2017, the A&B was defunct. Tommy's testimony did not delve into the details of A&B's collapse, but he testified that on the public launch date, the A&B, September 18, 2017, Ashley and her mother went to the couple's South Carolina home, retrieved her belongings, and went back to Florida. So, sounds like a breakup to me. I don't know what y'all think. Sounds like a breakup to me. While there was no testimony from Tommy as to when Doug moved to Florida, it was his understanding that both Doug and Ashley were on an apartment lease together, but he did not know if they ever lived in that apartment. In addition to describing Doug as being starstruck with Ashley, Tommy shared his observations that Doug was completely in love, completely supportive, and physically, you can tell by the way he treated her and took care of her. On cross-examination, Tommy Benefield addressed several of the allegations raised in the defendant's motion. As for discharging a gun inside the residence, it was Tommy Benefield's understanding that the discharge was inadvertent. Tommy provided no time frame as to when this inadvertent discharge occurred. As for Doug throwing the gun at Ashley and placing a tracker on the vehicle, Tommy did not remember those specific events being shared with him. As for the allegations that Doug was standing in the neighbor's yard and peering in Ashley's window at night, Tommy did not remember hearing from Doug and would have recalled such a story if he had heard it. As for striking the family dogs, Tommy testified that both Doug and Ashley told him that Doug was wearing shorts and sitting on a chair when the family dog, which Tommy described as a big dog with big nails, jumped on Doug's lap. The dog's nail Doug cut into Doug's leg, and Doug reacted by pushing the dog off of him. Doug told Tommy that the dog nails hurt. He was frustrated, and the force of the push was more than he wanted to do to the dog. However, Doug did not say he punched the dog or knocked the dog unconscious. As for punching walls, Doug told Tommy that he punched a hole in the wall one time out of frustration. As for domestic violence against Doug's first wife, Tommy stated that he was not aware of any such allegation. Tommy knew both Doug and Ashley had concealed weapon permits and that Doug regularly carried a firearm. So both of them had concealed carry permits, not just Doug. Stephanie Murphy was then interviewed. Stephanie Murphy is a family law attorney, has practiced for 21 years. She represented Doug in his divorce proceedings as well as for injunctions for that were filed by Ashley. Throughout her career in family law, Attorney Murphy has been seen aggressive and petty litigation and referred to the Benefield situation as extreme. So we already talked about how she was filing motions against him. This 21-year family law attorney is saying this situation was extreme in court. They were only married for like a couple of months. They were literally only married for a couple of months and got married after 13 days and still had a contentious divorce. That is insane. Attorney Murphy initially met Doug on March 13, 2018, and he paid her partial retainer the next day. At first, she was retained simply to negotiate with Ashley for Doug to be present at the birth of their child. The kid wasn't even born yet. How long were they together? Like a year? Because I think they met in 2017. or 2016. I can't remember, but they were not together that long. Okay. Let me see. Which was for him to be present at the birth of the child. In furtherance of this request, Attorney Murphy sent an email to Ashley on the morning of March 15, 2018, expressing Doug's interest and desire to be present for the birth, but also letting Ashley know that he would not attend if she felt uncomfortable. Neither Attorney Murphy nor Doug received a reply from Ashley from the email. On May 6th, Attorney Murphy learned that on or about May 1st, 2018, Ashley filed an injunction against Doug that her request for a temporary restraining order had been denied, and that a final injunction hearing was set to occur in a few days. Upon obtaining a copy of Ashley's petition for injunction, Attorney Murphy and Doug learned that the day after receiving Murphy's email, Ashley checked herself into Tampa General Hospital, began the process to induce labor, and delivered the party's child on or about March 19, 2018. Some 20 days early. She induced herself 20 days before her due date. That's ridiculous. Okay. This was how Doug learned his child's birthday and her name. Attorney Murphy testified that the injunction made a number of allegations, including Doug poisoning Ashley and their child in utero with heavy metals, abusing the family dog, threatening Ashley, and discharging a gun in the home. During cross-examination regarding domestic violence injunction cases, Attorney Murphy acknowledged that the males can sometimes be controlling in relationships, but that jealousy and possessiveness were some of the rarest reasons for domestic violence in cases she has handled. She also stated that both male and female victims of domestic violence can employ a strategy of appeasement in an effort to avoid violence in the relationship. The final hearing on petition for injunction was continued at Ashley's request, and Attorney Murphy filed several documents with the court, including a petition of parenting plan unconnected with divorce and a motion for a psychological evaluation. Attorney Murphy also filed an emergency motion for temporary time sharing and parental responsibilities because Ashley was not allowing Doug to have any time sharing with the child. The various cases and motions were consolidated and scheduled to be heard on July 20, 2018 and September 17, 2018 before Honorable Diana Moreland. Prior to the hearings, Ashley filed a motion to disqualify Judge Moreland, but the motion was denied. Ashley then moved to stay the cases pending an appeal, but that motion was also denied. So she didn't like the attorney. She didn't like the judge that eventually called her a liar, liar, pants on fire, which makes sense, right? That makes sense. She was trying to get rid of that judge. So because she probably was not getting rulings in her favor, so she tried to replace the judge. At the conclusion on hearing on July 20, 2018, the defendant was present when Judge Moreland delivered an oral ruling from the bench denying her petition for injunction. Judge Moreland also entered an order granting temporary time-sharing schedule that gave Doug an increasing amount of time with the child and eventually included weekend time sharing, overnight time sharing, holiday sharing, and travel to South Carolina to stay with Doug. Finally, Judge Moreland entered an order granting shared parental responsibility between the victim and defendant and giving Doug ultimate decision-making authority over the child's health and medical issues. That definitely would be something that would have antagonized her. She wanted control of the child. Child's not even 1 year old, guys. And the court said, Doug, the dad, gets to make all the medical decisions, final decision-making over the child's health and welfare, basically over the legal custody of the child. Mom might have had the child physically more often, but dad got to make the decisions. That's insane. Good move for the judge. The first time Doug met his daughter was in a parking lot at Manatee County Sheriff's Office on September 21st, 2018. When she was approximately 6 months old, Attorney Murphy was present for the first exchange, and though they arrived separately, Attorney Murphy was sitting in Doug's truck when Ashley arrived with the child. As Doug walked towards Ashley, Attorney Murphy heard Ashley ask Doug, "Are you dating her?" Attorney Murphy responded that they were not dating. The Benefields talked for between 5 and 10 minutes, with Ashley never getting far away from Doug as she held their daughter. At some point, Doug told Attorney Murphy that they were leaving and that Ashley was going with them. Attorney Murphy expressed her concern at the idea, but Doug told Attorney Murphy that he wanted the child to be comfortable and that Ashley is insisting on going with them. That's probably not what the court order said, but he agreed to it. It seems like he's being more willing to co-parent with her than she is with him. According to Attorney Murphy, what followed this initial hesitancy was approximately 11 months of peace that saw the parties enter into a joint stipulation to expand Judge Moreland's temporary time-sharing plan. Although, according to Attorney Murphy, Ashley was always present during Doug's time-sharing, the parties were also socializing together, and their photograph appeared in SRQ magazine when they attended the ballet gala event. Attorney Murphy pinpointed August 16, 2019 as the date that things changed and the downward spiral began. So for about a year, they was able to co-parent successfully together, but she would always be there. Ashley would always be there during his parenting time, which is a bit strange if they're not together and divorced, right? On that day, as his apartment lease was ending, Doug planned to move in with Ashley and her mother in a Florida home. Okay. He moved in, but they went through a divorce. Okay. Interesting. All of his belongings have been moved into the residence, but on moving day, August 16, 2019, Attorney Murphy testified that Ashley ghosted Doug. In November 2019, Attorney Murphy filed a motion seeking permission to amend Doug's petition to request dissolution of marriage. So now he's asking for the divorce now. So, so he hadn't asked for it before, but now he's asking for it. So I thought they already went through the divorce, but apparently not. After the first 5 months beginning in December 2018, Ashley made several complaints against Doug with Child Protective Services and sought another injunction. The CPS complaints were investigated but closed without any action or charges being filed. However, CPS required both Benefields to undergo a psychological evaluation, and Dr. Brad Browder was tasked on completing the evaluations. As part of the dissolution proceedings, the party were ordered to mediation. While the court did not allow any testimony regarding the substance of any statement made during the mediation, Attorney Murphy testified that there was an agreement for Ashley to dismiss her petition for injunction in exchange for Doug's dismissal of the dissolution case and withdrawal of the second emergency motion for time sharing and parenting plan. The parties also agreed to release Dr. Bowder's report. The mediation occurred on September 24th of 2020, 3 days before the what? So they had a mediation to get rid of the psychological event or to release the psychological evaluation, for her to drop her restraining order, and for him to drop his motion for more time. And then 3 days later, he was shot. Wow. The homicide and the 6 days before the parties were to appear in front of the judge for the final hearing. So, and they also had a final hearing coming up. And she just happened to unalive him right in that time frame. Did she think that she was not going to win her motions? Attorney Murphy stated that she never saw Doug angry with Ashley. To the contrary, she described him as very passive and very accepting, and that he was always trying to look for some explanation as to her conduct. While he was very suspicious of her, he was never angry. He also did not blame her for things, although he often blamed doctor who was involved with the poisoning allegation and lab results. Amanda Conlon is the next person. This is actually longer than I thought it was going to be. And I don't have the energy. I'm like stumbling over my words as always, but still. Ooh. Okay. So let's see. Amanda Cullen is a crime scene technician from the Manatee Sheriff Office, a position she held for 16 years. She was dispatched on the homicide at 7:37 and arrived at around 8:30 p.m. After being briefed, she went to the next door neighbor's house with the deputy and collected the firearm used in the homicide. She then reported the defendant's residence, took photographs, and measured and collected evidence. She noticed a U-Haul truck, a storage pod, and moving boxes. And although it was obvious that the residents were moving, there was still a couch and some furniture in the home. From the photographs and the diagram of the home, it appears to the court to be a typical 1-story, 3-bed, 2-bath, split plan residence, not unlike many of thousands other in the Florida over the last 20 years. The homicide took place in one of the smaller bedrooms. Considering the photographs of the diagram of the residence, trajectory rods, measurements, location spent, casing, location of fired projectiles, and position of the decedent's body, it is apparent to the court that the defendant was near the exterior wall and window facing the bedroom's door, so potentially walking out of the room, and the victim was in the bedroom doorway walking Walking into the room? Okay. I don't know. But the victim, okay, yeah. So she was in the room and then he was walking out of the room. Okay. Facing the bedroom door, and the victim was in the bedroom doorway to no more than a step or two inside the bedroom when the shots were fired. While there was a mattress leaning up against one of the walls and a few sawdry items on the floor, there was no furniture or other obstruction between the bedroom's doorway and the exterior window on the opposite side of the room. On the night of the homicide, a different CST took photographs of the defendant, and CST Cullen took photographs of the defendant a few days later on October 1st. The defendant argues that her questions and closing that the injury she suffered on at the hands of the victim on the night of the homicide includes scratches on the right side of her abdomen and swelling immediately above her eye. From reviewing defendant's motion, the court understands the significance and meaning of these particular areas to the defendant. However, there was no competent substantial evidence admitted during the hearing to prove the nature, cause, and extent of these injuries. The abdominal scratches appear superficial and are consistent with what one would expect to find after engaging in several days of packing up and moving a residence. There is no bruising or other trauma to corroborate the victim was slamming boxes into the defendant's sides and body checking her with his shoulder. As for the area immediately above the defendant's left eye, the swelling in the CST photographs taken September 27, 2020 and October 1, 2020 looks the same as that seen in defendant's booking photograph taken November 4, 2020, over 1 month later. If the swelling was acute as a result of trauma on the day of the homicide, there was no evidence admitted during the hearing to establish that fact. So, crime scene investigator basically says it was a clear shot from where he was shot and where the defendant was standing. Defendant Russell Vega has been a chief medical examiner for 20 years and has performed 3,500 to 4,000 autopsies, including gunshot wounds. He has experience in training and wound interpretation. Prior to the full recitation of Dr. Vega's education and knowledge, the defendant offered to stipulate to his qualifications. Depending on the nature of the case and the needs of the investigation, there are times when Dr. Vega will communicate with law enforcement officers during the evolution of the case. Otherwise he has no contact with the law enforcement. On cross-examination, Dr. Vega agreed with defense counsel that it's possible for a person to be an aggressor in a confrontation and not have defensive wounds. Dr. Vega performed the victim's autopsy on September 28, 2020 and completed his report on November 3rd, 2020. Upon gross examination of the body, Dr. Vega noted 2 clear gunshot wounds, 1 possible gunshot wound, and 2 other injuries, 1 to the back of the head and 1 to the back of one of the victim's thighs. Dr. Vega was not able to testify as to the order that the gunshot wounds were inflicted. The victim had no drugs or alcohol in his system. The gunshot wound to the right side of the chest. Let's see what the doctor had to say about that. On the right side of the victim's chest, to the right of the immediately adjacent to his nipple, there was a circular gunshot perforation of the skin. There was also some additional injuries to the area caused by emergency medical intervention when the chest tube was inserted into the chest cavity to relieve pressure and drain blood. There was no exit wound for this bullet, and Dr. Vega was able to trace its path across the body to the point of final rest just under the skin to the left side of the victim's back. The general path was right to left, somewhat front to back, and roughly horizontal, meaning the entrance wound and the final rest of the bullet would be around the same height above the ground in the victim if the victim was standing. After entering the right side of the victim's chest, the bullet went through the chest wall, went through the right lung, went through the vertebral body of the spine, but did not hit the spinal cord, went through the left lung, then went through the chest wall on the left side and came to rest under the skin on the left side of the victim's back. There was no deflection of the bullet as it went through the victim's body. That was hard for me to read. Dr. Vega opined that the muzzle of the firearm was to the victim's right side when the shot was taken. Gunshot wound to the lower right leg. Dr. Vega testified that the victim had a gunshot wound to the lower right leg, and he was able to track the path of the bullet. The bullet entered the inside back of the victim's right leg, more inside part of the calf, traveled to an upward angle, and exited out of his right leg near the knee. As the bullet transversed the leg, it struck bone, and Dr. Vega located a bullet fragment inside the victim's leg. The entrance wound was oval as opposed to circular, which told Dr. Vega the aspect of the gun to the leg was at an angle as opposed to perpendicular, and the shot was fired from below the entrance wound. So she was somehow lower than his leg, or it might indicate that she shot him as he was falling from the chest shot. Trying to figure it out, y'all. Much time was spent on both sides questioning Dr. Vega about the relative position of the muzzle and the victim's leg at the time of the injury was inflicted. Dr. Vega acknowledged that such injury could occur if the muzzle of the firearm was below the wound, such as if the shooter was on the floor beneath the victim's leg, as well as if the victim was falling. Yep, that's what I would think, is the victim was already falling from the first shot. His leg was raised above the plane of the body, his right hip was flexed, and his leg was in front of his body. Upon suggestion from the defense counsel that the leg wound could have come during a karate kick, I was not expecting to read that. Defense says it could have come from a karate kick. Why not just a regular kick? Why does it have to be a karate kick? Dr. Vega stated that it would have to be unique kind of kick, as it will require the victim, as he faced the defendant in a standing position, to expose the back of his lower leg to the defendant. Given all the evidence presented and the court's own opportunity to view the photographs of the victim's leg wound, the court does not find that the defendant was lying on the floor beneath does not find that the defendant was lying on the floor beneath the victim when she fired this shot. The court does not conclude that the victim was attempting some sort of unique martial art kick when this shot was taken. Love how he put that in there. The clear and convincing evidence supports the conclusion that the shot was taken either as the victim fell to the ground and his right leg rotated outward to expose the inside of his calf to the muzzle of the firearm, or he laid on the ground with his leg in the air or on the ground with the knee bent in such a way that the inside calf was exposed to the muzzle of the firearm. Yeah, I agree. I agree with the court. I'm not going to go through the superficial abrasion on the right arm. Seems like that probably grazed them. Head to the injury, it was shaped as the same as the wall. An injury to the back of the thigh. This was a very minor injury and barely noticeable. Dr. Vega had no opinion as to how the injury occurred, and it would not have been debilitating or caused any problems. Considering all the findings, Dr. Vega concluded that the victim's death was caused by the bullet that transversed his chest and went through his lungs. I mean, that's pretty obvious. Dr. Vega was not able to determine if the victim was immediately incapacitated, and the victim could have had the ability to make some purposeful movement after being shot. However, Dr. Vega stated that people who suffer similar gunshot injuries fall pretty quickly. Yeah, I would imagine. Okay, we got Rich Tomball, who is also a crime scene investigator of 23 years and manager of the department for 20 years. He had supervisory duties of the crime scene. On the day of the homicide, Talbot assisted Conlon with her processing of the scene, including assistance with the trajectory rods that are seen in the photographs. A few days later, he returned to the home with a Rudolph to scan the area with a laser scanner. No details were provided to the court about the scan. On October 6, 2020, Talbot used a regular camera and an infrared camera to process the victim's shirt for any gunpowder residue, soot, or stipulant. Upon his initial examination, Talbot located one hole that he identified as a bullet hole. Next, using both cameras, including 3 different lenses with the IR camera, he took multiple photographs of the victim's shirt, but he was unable to view or identify any gunpowder residue, soot, or stippling, which basically shows that she was not standing close to him. To his understanding, Talbot testified his findings was indicated that the muzzle of the firearm was more than 3 feet from the victim when he was shot, and the chest, and potentially 4 or more feet away. So she wasn't right up against him. He wasn't actively attacking her, like physically on her when the gun was shot, is what this crime scene investigator is testifying to. And then we got Detective Warren, has been with the Manatee County Sheriff's Office for 20 years. And he's on the homicide investigative unit, and he's the lead detective on the case. On the day of the homicide, the call was made around the 911 call was made around 7 p.m. and Detective Warren was notified around 7:20 p.m. While he gave assignments to other detectives and law enforcement officers, he initially reported to the sheriff's office to draft the residential search warrant. And communicating with other law enforcement personnel, Detective Warren learned that a self-defense claim was being asserted. The defendant's impeachment of Defendant Warren comprised three main topics: how quickly he obtained a search warrant for the residence where the homicide occurred, his reference to murder in the application for the residential search warrant despite the nascency of the investigation, that the investigation was new, and inconsistencies between two prior versions of the probable cause affidavit narrative that were emailed to the prosecutor in the final PCP. So this detective was impeached. So that's interesting. As for clarity, with the Detective Warren obtained the residential search warrant approximately 1 hour, he testified that this was not unusual and that the reviewing magistrate, the judge, did not ask him any questions. In addition, Conlon, the crime scene investigator or technician, who had no role in applying for the residential search warrant, testified that getting a residential search warrant quickly was routine for her agency. The court does not find Detective Warren's testimony incredible based on the amount of time it took him to procure. So the court did not impeach him on that, but the defense wanted him impeached. As for Detective Warren, use of the word murder in reference in the application for the search warrant instead of a more generic reference to homicide, the defendant implies that Detective Warren rushed to judgment by calling Doug's death a murder so early in the investigation, and that his credibility should be diminished because of the jaded lens. Okay. So let's see. In some, the court does not find that he's less credible because he used the word murder in the warrant than homicide. And then finally, the defendant sought to impeach Detective Warren with two versions of his probable cause affidavit narrative that were emailed to the prosecutor before being finalized into the version that was used to initiate the case against the defendant. The main thrust of the defendant's impeachment were that from the first draft of the final version, the detective softened the victim's violence toward the defendant in the moments immediately preceding the homicide and anonymized the source of the information about the defendant's injuries caused by victim on the day of the homicide by removing the therapist's name. So remember, they said a witness said the scratch came from something at work, but they're saying that it was the therapist who was the witness, essentially. The defendant's cross-examination attempted to show that detectives' original drafts of the probable cause affidavit narrative specified that the defendant's therapist referred to the victim's physical contact with the defendant as scraping and body checking, but the final version of the PCA narrative described the physical conduct as inadvertently scratched and did not provide the source of the information. The defendant argues that this was detectives' effort to lessen the chance that a reviewing magistrate would ask questions about the incident and perhaps refuse to sign an arrest warrant on the basis of the stand your ground immunity. Having heard the cross-examination on the issue and considered the argument of counsel, the court does not consider Detective Warren PCA narrative, the prior drafts, and it's a draft. He's trying to figure out what to write. The multiple levels of hearsay represented in the PCA narrative or the edits made by PCA narrative prior to the final version to be competent, substantial evidence, and the court does not discount Detective Warren's credibility because he communicated with the prosecutor about the content of the PCA narrative or because he made changes and edits to those prior versions before settling the final version. The court reviewed the final version of the PCA narrative that was submitted to the court, and in light of the information learned about this case during the stand your ground hearing, the court does not find it to be misleading or incomplete, so as to constitute fraud on the court and or utterly lacking probable cause. So the court did not impeach him for what the court said. Okay. So there's a little bit more to go through. I'm not even gonna lie to y'all. I don't have the energy to go through it all. So there's a little bit more testimony. They go through the victim's cell phone. So maybe I should cover that part. Yeah, let's go ahead and cover that part. What's in the cell phone? And there were some other people interviewed and they analyzed the actual injuries. Apparently, the defense thinks that the victim was doing karate kicks. Don't know where they got that from. So let's see what was going on in the cell phone. As part of the investigation, Detective Warren came into possession of the cell phone. He did not do a complete forensic download, but he viewed the contents. Among other things, the defendant or Detective Warren viewed the forensic download was a confirmation email for the local pickup U-Haul truck in the return to Bowie, Maryland. He also found the victim was conducting searches to find a roommate in the same area as Maryland and contradicted information he received that the victim was moving in with the defendant and her mother in Maryland. The state then sought to introduce numerous text messaging attachments from the victim's cell phone. While defendant stipulated to the authenticity of the text and attachment, she objected to hearsay and relevancy grounds. The state argued that the defendant's portion of the text were clearly admissible and that the victim's portion of the text were not being introduced to prove the truth of the matter asserted, but to show the nature of the flow of communication between parties in the days leading up to the homicide. In keeping with this theme, the state argued that the relevance of the text was to show that Benefield's communication were not angry, threatening, or hostile, which contradicts the defendant's claim in her motion that the arguments of her counsel, the court was not provided the text messages or attachments prior to the hearing and found it difficult to make a ruling without seeing them. Subject to defendant's objection, the state was allowed to proffer the text and attachment. However, having now seen and heard the text and attachment introduced by the state considering the arguments of the party on relevance and hearsay, the court admits and considers the text messages and attachments over the defendant's objection. Those portions of the text messages from defendants are admissible. While not ruled upon individually, those portions of the text of the attachment of the victim are admissible variously as to not being hearsay and that they are considered by the court for the truth of the matter asserted as spontaneous statements and then existing mental, emotional, and physical conditions. As for relevancy, the court finds that the text and attachments are relevant and they support the state's position that there was no anger, threat, or hostility between the parties. Let's see. Every morning on September, I think it means early morning, but it says every morning. Oh, no, it does. Every morning from September 20th, 2020 and September 27, 2020, the day of the homicide, Doug texted an attachment to Ashley with a Bible verse throughout the week. They exchanged pleasantries and responded positively to each other's messages with like, love, and laugh interactions. There were text conversations about the upcoming move, packing up boxes, making sure the pet cats were put away, picking up the U-Haul supplies that were needed, scheduling time to continue working, and coordinating the delivery of the vehicles to Maryland. On September 23rd, 2020, the parties discussed the beauty of the day and planned to take their daughter to Sarasota to enjoy the weather. The state played a video that was attached to a text sent by Doug to Ashley on September 20, 2020 at 6:40 p.m. The court was unable to understand much of what was said, but the video was recorded by a male, presumably the victim, as he sat across from the defendant on the left of the screen and her mother on the right of the screen in a booth at a restaurant or bar. The parties were engaged in small talk and banter, occasionally laughed, and appeared to be having a typical family night out. There were no harsh words or raised voices, and neither of the women appeared to be in distress. The court did not see a date of the recording of the video. Other attachment by Doug and Ashley included photographs of the defendant and their daughter at the beach. There was also text about upcoming mediation agreements of the party intended to make, actions that needed to be taken to resolve the pending family law matters, and references to a joint counseling session that was scheduled. They made plans to meet the night before in the morning of mediation to finalize their intentions and tell their respective attorneys what they wanted. And then by text, the parties exchanged texts about how quick and easy mediation was. On the day of the homicide, the morning started at 6:42. Doug sent a Bible verse to Ashley. Later that morning, they exchanged good morning texts. After 1 p.m., the parties exchanged texts comparing what they had done that day. what they were working on in the moment, and what the plans were for the rest of the day. The routine and mundane topics of the past week were repeated as Doug provided updates on his packing progress and need to get the dog to the spot for grooming, and Ashley asked him to pick up more boxes and tape on the way over. So we have text messages starting at 3:54 p.m. Doug texted that he was in front of the defendant's residence, and Ashley asked for a minute, presumably before he came into the house. At 5:10, Doug texted that he was about to head back and sent an attachment that could not be opened by law enforcement. 5:11, Doug texted that he had everything in presumably the U-Haul except a couch, 10 medium-sized boxes, and a tutu cab. To this text, Ashley reacted with a laugh and sent a haha OMG. So this is just at 10 o'clock. The shooting happened sometime around like 6:30. I'm sorry, this is just at 5 o'clock, and the shooting happened sometime around like 6:30. So they're sending haha text messages right now, right? 5:32, Doug texts his trucker on the way. This is the last text presented by the state. The 911 call was made at 6:56. Okay, so so around 7 o'clock, an hour and a half later, there was some anger after texting about what was in the U-Haul, apparently. The court finds that the written objective communications between the party in the week leading up to the homicide and on the day of the homicide, including text back and forth no more than 2 hours before the homicide, reflect normal conversation of a husband and wife engaged in seemingly cordial dissolution and working together to pack and move two residences across the country. The text and attachment were devoid of anger, threats, or hostility by the victim toward the defendant, and support the state's position that there is no evidence to conclude that the victim's demeanor suddenly, radically, and inexplicably shifted to homicidal violence toward the defendant that would justify her use of deadly force. They go ahead and interview some more people. They actually interview the doctor that was supposed to do the psychological evaluations on both of the parties. I know I already said it. I don't have the energy to go through this. I can barely keep my eyes open right now, y'all. I did not sleep last night, so I'm sorry. We're not finishing the document, but I think that we got the gist of what happened in the hearing, denying the dismissal. I don't think, even if we read the motion, which we can still read the motion for the dismissal, her evidence and the conversations that were had and the testimony from the crime scene, just based on those things in the doctor, I don't think she has self-defense. They seem fine, and not saying that they couldn't have gotten in a fight in the hour and a half after those text messages, but it seemed fine. And it doesn't seem like she's presented any other evidence of any physical harm before. She already had a failed restraining order hearing. They decided to dismiss all of that stuff. I don't see where she's coming from. And maybe y'all do. Let me know. I was tired of reading, y'all. See, sorry. Couldn't even finish my yawn before Bossy B was done. Okay, let's see where we are with our likes, because we are at 37 likes. Our like goal is 50. So if you haven't hit the like button, we can possibly still make it. We can possibly still make it to our like goal. Let's see what the chat has to say about the case. As I talked about earlier, I stated that the court decided with the state. I agree with them. It sounds like I don't know. Why did she get back together with him? I'm confused about that. Anyways, let's go on. Stargazer Kawaii says spooky, right? Destined to Be says, I thought I heard something, but she was yawning, so I ignored it. No, it sounds like someone is falling through my house, right? Tiny D says, was he her sugar daddy? I don't know. 30 years apart, right? They got married though in 13 days, which is insane. That part is insane to me. Kimmy Locker says to Tanya D, I mean, doesn't sound like he wasn't, right? We can't say that he was, but we can't say that he wasn't. Stargazer Kawaii says men can still be strong at 54, especially if they work out. The fittest man I know is in his 60s and a former firefighter. And I'm not saying that he wasn't strong. It's just that she doesn't have any evidence of this alleged abuse, and the guy that could potentially testify against her, she unalive. No, I'm not saying he's not strong. I'm just saying that I don't like the age gap. I don't like the age gap, like relationship wise, not like strength wise. Kimmy Locker says, having to retain a divorce attorney to negotiate being present for the birth of your child with someone you married within 2 weeks of meeting is wild. Yeah. And then he reverses vasectomy for the child. And then she has the nerve to be this rude. Tanya D says, so much drama in just 2 years. In just 2 years. Stargazer Kawaii says, did she leave him as soon as she found out she was pregnant? It seems like almost immediate, but not all the way. Just, she was still pregnant when she left him. Stargazer Kawaii says, very odd relationship. I agree. It's a real roller coaster. Agree. They got back together in the middle of a divorce and restraining order hearings. Stargazer Kawaii says, so at what point of this relationship did she think he killed his ex? She said that he poisoned her. It's the ex dead. I don't know if I got that one. I'm probably going to get red flagged for saying dead, death, murder all the time throughout this stream. Stargazer Kawaii says, so there's a very, very small chance he gave himself a visible injury kicking her, but she didn't get any visible injury from being kicked by him. Right. So she's saying that the bullet went through his leg because he was trying to karate kick her from like 4 feet away. So he has really long legs. Kimmy Lockett says, yeah, compared to some of the investigative nonsense we heard in the Rustin Karen Reed case, word choice is super tame. Stargazer Kawaii says, so where exactly was he killed? It sounded like he hadn't moved into the house in Maryland, in their house in Florida. So they were moving out of the house in Florida. So he was packing boxes and helping move into a U-Haul. And somehow she shot him. Somehow an argument ensued and she shot him. Stargazer Kawaii says it definitely sounds like he was moving from his house and she wasn't living there. It was her mother and her house, or I guess her mother's house, that they were living in with the mother. And they all were getting ready to move to Maryland, from what it sounds like. Or at least Ashley and Doug were getting ready to move to Maryland, from what it sounds like. Stargazer Kawaii says it's sus. Chelsea B says, now that poor kid has no parent. Yeah. Essentially is what's going to happen because you wanted to keep all control. And remember, the court just ordered that dad was to have final decision making authority for like the last year. The kid is only like 2 years old at this point. I don't even think she had hit 2 years old. Probably like a year and a half. I think everything was going good for a year and a half. And then boof, this. It's so sad. Oh, sorry, y'all. I'm tired. It's a sad case. I feel bad for the daughter. I don't think her story is going to stand up in court. I think they're going to get her. I don't think she has a self-defense claim in here. Unless she can show some other evidence of him being violent in the past to prove her point. And everyone's saying he's pretty mild temper and she's the only one saying that he's cuckoo. Maybe her mom will come out and testify because he's lived with the mom before. But so far, I don't think she has a good defense. Anyways, y'all, I'm not finishing the rest of that document. That's all I have for today. But anyways, we're going to have some pre-records, or not some, but at least one pre-record released over the weekend. I am going to try, and I know I told Kimmy that I can stream on Tuesday and Thursday for when this trial starts, but given my workload at work, I don't know if that's true all the way, Kimmy. So don't quote me on that. So I'm going to try to stream on live on Tuesday and Thursday, but we may not get to do it due to my work schedule to see what's going on with this trial. And then we have some other interesting cases that have come up that I'm going to do the pre-records on. So if there are any cases that anyone has heard of and they would like to cover, please feel free to drop in the comments. Let us know what you guys want to hear about next. We are going to be diving into this trial, which is probably going to start sometime next week. And again, we have some pre-records coming. I hope that everyone has a wonderful night, and I hope that I actually sleep tonight because I can barely keep my eyes open right now. So thank you all for coming in the live stream. Let me see. We didn't hit our like goal, but that's okay. Anyways, thank you everyone for joining the live stream and interacting in the chat. I will see y'all all on the next live stream. Bye.